The end of cash bail in Illinois kicked in September of 2023, and since then, there have been several issues popping up about who should be detained before trial and who should be released before trial. Illinois being the first state to end cash bail, and the experiment playing out all the way to the Illinois Supreme Court. Good morning. It's Illinois in Focus Daily. I'm Greg Bishop, associate editor for the Center Square. Like, subscribe, hit that notification bell, and wake up with us each and every weekday morning at 8 o'clock. We go live, telling you what's going on throughout the state, and especially at the Capitol. All right, I'm a State House reporter. I'm an associate editor. I follow what's going on in the Illinois House, in the Illinois Senate, the legislative branch of government. I also track what the executive branch is doing, Governor J.B. Pritzker, but we also look at what the judicial branch is doing with the court system. So go to thecentersquare.com, get the newsletter, register for that. You can get national headlines in your inbox, and you can get state headlines in your inbox. But the headline yesterday, no cash bail cases challenged in 2 Illinois Supreme Court hearings. Yesterday, we previewed these cases, and it gets down to the question of the timing of when a pretrial detention hearing should be had, and whether a pretrial detention hearing is substantive enough, and should there be more clear guidelines on what kind of substance should be allowed during a pretrial detention hearing. So let's just take a step back here really quick and give you the background of the Pretrial Fairness Act, which was part of the Safety Act, which was safety, accountability, fairness, equity today. Safety Act. This passed in the wee hours of the morning in one of the chambers, January of 2021, lame duck session. This is after COVID, the peak of it, and the State House is holding session at a convention center in Springfield to have social distancing. I was sitting in a car outside the chamber, listening to it live, writing stories. So they passed the Safety Act, which was a comprehensive criminal justice reform and police regulation bill. So they passed this comprehensive package, and in the package, it included things about, restricting police from doing certain things, and some other criminal justice reforms, but it also had the Pretrial Fairness Act in it, and that would end cash bail statewide, saying that these are the offenses that are non-detainable offenses, and a prosecutor has to go to a judge within 48 hours of somebody being arrested to have a pretrial detention hearing, to go in front of the judge and say, Judge, these are the reasons why this individual needs to be held pre-trial without any kind of bail, right? The system before the Pretrial Fairness Act included judges saying, hey, you've been charged with this crime. If you want to be free before trial, you're innocent until proven guilty, but if you want to be free before trial, you have to pay X amount of dollars. And then if you're found innocent, you'll get that money back. If you're found guilty, then that goes towards restitution and a whole bunch of other things. So there's the idea of the money there. But those who pushed for the Pretrial Fairness Act said too often people of lesser means are getting stuck in county jails because they can't pay a $500 bail to get out on a low-level crime. And then their whole life is turned upside down. They lose their job. They might have health issues. They miss out on appointments and so on. Just a lack of freedom and the idea of you're innocent until proven guilty, right? And you're proven guilty. That whole trial is, jury of your peers and such. So the Pretrial Fairness Act passed in 2021, but it had an on-ramp. It was going to take a while for it to actually be implemented as the state's court system conformed with what the state legislature wanted. But then you had states' attorneys sue, and they sued all across the state, went through the district courts, appeals court, and then went all the way up to the Illinois Supreme Court, which held the law from going into effect until they heard it. So there was about an 8-month delay from when the law was supposed to go into effect to when the Supreme Court actually decided, you know what, yes, this is legit. We're going to go ahead and allow this to go into place. And that was September 2023. So that's kind of the background here, right? So now it's been in place for like a year and a half, right? And there's been all kinds of studies and research showing statistics of the number of people who are not showing up for their trial, not showing up for their court dates, because that was one concern that law enforcement had across the state was you're going to have people that are let out pre-trial, either on an ankle monitor or certain conditions are set that they have to meet, and they're not showing up to their detention or they're not showing up to their court cases. So then you have, orders of no show, and you've got police having to go out and issue warrants and such. So there's all kinds of issues that play into this. But yesterday, the Illinois Supreme Court heard a couple of cases dealing with the issue of no cash bail. So Tuesday, you had Illinois versus Antonio Cousins. It's a case involving firearms. And what you had here in 2021, the trial courts denied pretrial detention in 2024. The state was trying to keep Cousins behind bars, arguing he posed a danger. Then the 4th District Appellate Court sided with the state and ordered another pretrial detention hearing. Cousins appealed to the Illinois Supreme Court. Well, yesterday, the Illinois Supreme Court heard from Cousins' public defender, and this is Laura Bowser. She shared why she thinks that the Supreme Court should deny another hearing for prosecutors to try to keep her clients behind bars.
An issue in this case is, what is the proper remedy under the Pretrial Fairness Act when a reviewing court finds that there was insufficient evidence presented at a detention hearing on one of the statutory elements of detention?
So you got, again, the idea of this pretrial hearing where prosecutors are within 48 hours to tell a judge, hey, these are the reasons why we need to keep this person behind bars. Apparently, in this case, the trial court didn't really, according to the state, the assistant state's attorney, which we'll hear from here in a moment, said that they weren't given ample opportunity to make their case to say Cousins needs to be kept because flight risk, dangerousness, prior record of similar firearms offenses. This individual needs to be kept behind bars pending trial. So here's Assistant Attorney General Eric Levin making his case in front of the Illinois Supreme Court yesterday.
And so we're just asking for this to be sent back for another hearing. I would note that I don't know that it will have much effect in this case as a practical matter. It's my understanding that trial is set for late April. So the case could become moot. It's not moot yet. I don't know that the trial will go ahead, but I do think it's important as or I should say that the sort of overarching issue of, in circumstances like this, is automatic release appropriate? I think it would be important for the court to say that no. I mean, we're not going to just say, we're not going to have like sort of a gotcha system where the hearing didn't go as it should have gone, and so that was the state's only opportunity, and we're just going to release a defendant without regard to whether or not the evidence shows a danger or a flight risk.
So the arguments back and forth, when you watch these types of hearings, you've got the people who brought the appeal, being Cousins' public defender, making their case, and then you get the state, in this case, making their response, and then you get the public defender coming back for a rebuttal, and here she is saying that the state asking for another hearing it's too late. They had the hearing already.
We had a full hearing on this question. It's not a question of automatic release. It's just enforcing the presumption of release that is written into the Pretrial Fairness Act that the state did not meet its burden to overcome.
So the state didn't meet its burden to overcome during the initial case when it was heard by the trial judge. And then the appeals courts took their action. Now it's up to the Illinois Supreme Court to see what they do. But another case that was heard yesterday is from 2024. It's Illinois versus Tyrell Cooper. It's a similar firearms case. And the appeals court reversed detention and ordered pretrial release from the trial court's decision. So what this case is all about is that 48-hour period. All right, so you get arrested for stealing some sneakers. You get processed through the jail. 48 hours is a window that prosecutors have to go in front of a judge and say, hey, this person needs to be kept behind bars pending trial because they're a flight risk or they're dangerous to the community or whatever the case may be. And that 48-hour window apparently includes weekends. So if you were arrested Friday night, then by Saturday and then Sunday night, you need to have a pretrial detention hearing or you're presumptive and allowed to go free pending trial. Well, in this particular case, similar, they didn't have a pretrial detention hearing until like Monday afternoon. So obviously beyond a 48-hour threshold, the state argued to the Supreme Court to affirm the lower court's decision on pretrial detention. Here is Assistant Attorney General Aaron O'Connell.
This is the court's second pretrial detention case of the morning. The biggest difference between this case and the previous case is that everybody here is in absolute agreement that the substantive nature of the circuit court's order of detention was correct as a matter of law. It was supported by sufficient evidence. The court correctly determined that this defendant could not be released without endangering the community. The question presented here is whether an alleged timing error in the holding of a continued detention hearing deprive the court of its authority to enter that order.
So the idea was that 48 hours a mandate,
the legislature
or was
it
more of a kind of suggestion? The counsel for the criminal defendant in this case, Jonathan Krieger, he said, listen, the 48 hours is a mandate because it's written into the law, and it includes weekends. If it didn't, they would have excluded that when legislators wrote the law.
The legislature, in crafting subsection C2, could have excluded weekends in general, and it didn't. It has done so in other statutes by choosing to exclude that provision in subsection C2. That should be given effect.
So what are we going to see here? Is the Illinois Supreme Court going to clarify for the legislature
but the
what
court,
exactly the 48 hours means, whether or not a trial judge is going to be able to hold a proper hearing in proper course to allow for prosecutors to make their case on pretrial detention? These are two pretty strong issues, and the Assistant Attorney General here for this second case closing out, essentially saying that, hey, this 48 hours, it's just a suggestion.
but the court should answer the question of the mandatory directory dichotomy by holding that it is directory, and then that ends this case. They're even assuming that this was 2 hours late. He's not entitled to invalidate the detention order, and the court's authority to detain him was preserved.
So we'll watch closely for when the Illinois Supreme Court makes their ruling. Both of those cases were taken under advisement, as they say, which, if you're not familiar with what that means that they're going to deliberate behind closed doors and come out with some ruling sometime soon. When exactly that'll be, don't know. That's the thing with courts. Anybody who's been watching the U.S. Supreme Court, for instance, trying to find out if they're going to take the Snope case, and any observer you talk to who watches courts, the justice system moves at their own pace. And reporters, taxpayers, we're kind of just hanging out waiting for stuff to drop. So that's kind of how it goes. But follow us, the Center Square, YouTube, X, get the newsletter, podcast. Wake up with us each and every weekday morning. We'll keep you posted, all right? It's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, and hit that notification bell.